But he says here, can you spend time explaining how the Declaration is still a lawful document? It seems to be treated as a museum relic because the Constitution is the law of the land now. And that's a great question, and that's what you will hear. And to answer the question on family, we got to go to the Declaration because the answer is in the Declaration, but the instant argument will be exactly as he expressed. The solicitor will say, yeah, but we're not under the Declaration. We're under the Constitution. So let's first deal with the fact that, no. If you're under the Constitution, you are under the Declaration. You cannot separate the two. Four things prove that. Number one is Article 7 in the Constitution. All right, so the Founding Fathers, they did the Declaration in 1776. 11 years later, they did the Constitution in 1787. Most of the guys who did the Constitution had not been part of the Declaration. Only 6 of the guys who signed the Constitution signed the Declaration. So by and large, you've got a different set of folks. And so they're creating a new document, right? Wrong. When they get that document done in 1787, they dated it back to the Declaration of Independence. They said the Constitution is based on the Declaration, and they said, done in convention by the unanimous consent of the states present the 17th day of September in the year of our Lord, 1787, and of the independence of the United States of America, the 12th. What they did was they dated the Constitution to the Declaration. There was a continuation, not a replacement for the Declaration. It was to form a more perfect union. We set out the principles in the Declaration. Now we're showing you how those principles apply. We're not renouncing the principles. We're incorporating them. As a matter of fact, we're telling you that this document is the continuation of what we started 12 years ago with that document. So you've got guys who didn't do the first document recognizing the first document is the basis of the Constitution, and that's why to this very day, Rick, when President Obama signs a law this week, if he signs one that goes through Congress rather than the executive pen and the phone that he has, if he signs a law,
yeah,
it will say that this is done in the year of our Lord, 2014, and of the independence of the United States of America, the 238th. He will date every act that he does to the Declaration, not just to the Constitution. So he will give the year and date it to the Declaration. That's the way every presidential act is signed today. So tell me why it is that the Declaration doesn't matter, that we're only under the Constitution, the Declaration is irrelevant. The Constitution itself repudiates that, as does all the acts of the President. Second proof is you look at the enabling acts. Now, I'm not sure what state Pete's from, but the enabling acts for the states required, for example, I'm looking at one here. These are the enabling acts are the acts where Congress says you've been a territory, now you can become a state of the United States if you agree to this contract. Here's the contract you have to sign. And so I'm looking at Colorado, Nevada, Nebraska. It says the state constitution, when formed, shall be republican and not repugnant to the Constitution of the United States and the principles of the Declaration of Independence. So your condition for statehood was the Constitution and the Declaration. Not one or the other, but both. Here's Oklahoma. The state constitution shall be republican in form and shall not be repugnant to the Constitution of the United States and the principles of the Declaration of Independence. There's another one. So you go through, your requirement to become a state in the United States was that you abide with both documents, not just one. Here's proof number 3. The U.S. Code is what you argue in federal court. That is part of Article 6 of the Constitution, the Supremacy Clause, the federal law. And federal law begins by identifying the 4 organic laws of the United States, which no state or federal law is permitted to violate. Those 4 laws include the Declaration of Independence alongside the Constitution as one of the 4 laws that no federal law and no state law is allowed to violate. So that's the third proof. The Declaration is still active today. And the fourth proof is you cannot understand the Constitution if you do not read the Declaration, because the clauses in the Constitution are corollaries to what the Declaration raised as a grievance. For example, when the Constitution says in Article 1, Section 5, that neither House, during the session of Congress, shall, without the consent of the other, adjourn for more than 3 days, nor to any place other than that in which the 2 houses shall be sitting, you have no clue what that means until you read the fourth grievance of the Declaration, which says, he has called together legislative bodies that places unusual, uncomfortable, and distant from the depository of their public records for the sole purpose of fatiguing them into compliance with his measures. Oh, since that's a grievance, we're telling you that you cannot dismiss legislative bodies, and they will meet in one place and not all over the country, and they will be there where the public records are. And so I can do that. I'll show you grievance 5 and 6 of the Declaration, how that is solved in Article 1, Section 4 of the Constitution. I can show you grievance 7 of the Declaration, solved in Article 1, Section 8, Paragraph 4. Grievance 8 in the Declaration, Article 1, Paragraph 9 of Section 8. I mean, all the way through. You cannot handle the Constitution if you don't know the Declaration. So that's 4 proofs that the Declaration is still active today. The solicitor is wrong. And the liberals who want to dismiss, liberal progressives who want to dismiss the Declaration because it's not the Constitution, they're dead wrong. They know nothing about the Constitution or about history.
All right, so the Declaration is definitely still in play. Now the question is natural law. What does that mean? Got to take a quick break. We'll come back and talk about that when we return right here on Wild Builders Live. On Thursday, we're talking about those principles that made the country great, and our question this week has to do with the Declaration of Independence, and now also has to do with natural law. What is that, and how do you govern from that perspective of natural law today in our legislative process? David?
So when you look at it, at what we've been looking at, I got to say one more thing about the Declaration and Constitution. The U.S. Supreme Court has ruled that the two go together. Founding Fathers said the two cannot be separated. Sam Adams said we did not replace the Declaration. It's the foundation. As a matter of fact, John Quincy Adams said it this way. He said the Declaration of Independence and the Constitution of the United States are parts of one consistent whole. He said those principles proclaimed in the Declaration are embodied in the Constitution of the United States. You can't separate the two. So, to answer the question of natural law is not part of the Constitution. It is part of the Declaration. Now, it became part of the Constitution through the 7th Amendment, through the common law, but if you don't understand what it is in the Declaration, you have no clue what it is in the common law of the 7th Amendment. So let's go back to the Declaration. To understand natural law, you got to understand the 6 principles of the Declaration. Let's just take the first 3. The first 3, the founders said there is a creator. Second point they said is the Creator gives certain guaranteed inalienable rights. And the third point they said is that government exists to protect those rights. Now, those inalienable rights, the Founding Fathers also called natural rights. According to John Adams, inalienable rights or natural rights are the rights which occurred before government ever existed. In other words, they're rights that God gave you as an individual. They didn't come from government because when God gave you these rights, there was no government. So an example of that is the right of self-defense. Government did not exist till Genesis 9. All of the natural rights appear in Genesis 1 through 8. They're laws that you can see in nature, which is why they're called natural rights. They're law of nature. So when you look at nature, the right of self-defense came before government ever existed. It is in nature that they will defend their young. They will defend their home, what they consider to be their living space. They will defend their own life. There's no law you can pass to stop self-defense. We are in the country. I raise sheep and horses and cows, etc. And this last winter, we had a ewe that, for whatever reason, our cat just really liked this ewe. And they would, when the sheep would all lay down at night in the pasture, this cat, wintertime, would go crawl up under the wool of this one ewe and lie there in the pasture and stay warm. And that worked really well until that ewe had twins. And the night that she had twins and that cat went out there to crawl up under that ewe and lay there under the wool like she had been all along, that ewe pounded her into the ground. Now, that's her natural right of self-defense. She perceived that to be a threat to her 2 young lambs that she had there. She's going to defend those lambs. Congress can pass any law they want saying that sheep cannot pound cats in the ground and won't make any difference. That's a natural law. That's a natural right, the right of self-defense. You have the same with families. Families existed before government. They exist in Genesis 1, 2, 3. You have Adam and Eve, then they have children, Cain and Abel and Seth, etc. Jesus. So
these things are not natural law. Then it's not like theory. I mean, this is just the way it is and the way it has been from the beginning.
This is well established. If you want to take any law book other than those in the last 20 years, natural law is defined as the laws of nature. The Declaration called it the laws of nature and the laws of nature's God. The God who made nature knows the laws of nature, and he put laws in nature, just like there's a law of gravity in nature. There is a law of all sorts of things in nature. I mean, it's there. Those are the laws of nature. So to say that we really don't know what natural law means and struggle to define it, that's because for a liberal progressive there are no absolutes, and when you look at things like gravity, that's an absolute. When you look at self-defense, that's an absolute. When you look at the definition of family, man, a woman, and kids, that's an absolute. And so they are really having a tough time trying to redefine things that are absolutes, and that's where the Declaration made it so clear. Now, if you reject the Declaration Then the Constitution becomes nebulous. It evolves. It is a living document. It is whatever we, the solicitors, we, the attorneys, we, the judges, say that it is. But when you attach it to the Declaration, that's where you get your fixed values, and that's what keeps the Constitution founded on strong, firm values that transcend generations, centuries, and millennia.
All right, we're going to take a quick break. Let's talk about how we need to apply it, how people at home need to study it. What can they do to make it? Today we're talking about natural law. And David, our question was really specific to this too. I mean, how do you do that in our legislative system today? And how do we as citizens make sure that our representatives understand this, and how do we judge them and when we go vote based on this concept of natural law?
You know, one of the easiest ways to tell about natural law is ask them where they are on abortion, because they do not respect the inalienable right to life. They do not respect any other inalienable right, including the right to family, the right to self-defense, the right to, as I mentioned, the Founding Fathers had about 24 natural rights. The right of expatriation, we probably don't have a clue what that means today. Jefferson, Franklin, Adams all talked about the right of expatriation. You have the right of profit making. They identified that as a natural right. You have all sorts of rights. And the founders made really clear, Sam Adams and James Wilson, others, that if you don't respect the right to life first, you won't respect the other rights. That is the first of rights. So if you don't respect the right to life, you don't respect property, you won't respect protecting income. You'll think that you ought to tax people more rather than protect their income. You'll take it from them. You won't protect their property. You won't protect their religious liberties. You won't protect their right of self-defense. You'll try to take the self-defense away from them. It all goes back to that's the easiest answer I can give. If they are wrong on the issue of abortion, they do not understand inalienable rights. They do not understand natural rights. By the way, there's a natural right for you. More than 10 million species in nature. Not a single species in nature kills its young while it's still in the womb. That's a violation of all natural process, all natural rights. I don't need a religion to tell me that. There is nothing in natural law that kills its young while it's still in the womb. So that's the easiest thing I can point to. I don't care whether they're running for dog catcher or president of the United States. You ask them where they are on abortion. And by the way, when the dog catcher says, wait a minute, I'm running for dog catcher, it has nothing to do with abortion, you say, yeah, that's true, but that will tell me your entire philosophy of government. And by the way, you may not stay dog catcher. You might run for school board or city council. You might run for mayor or state representative. You might run for governor. And it's a whole lot easier to knock you off as a dog catcher than it is to knock you off as a governor. And so you ask that question of anybody that runs for office, where are you? I'm on the school board. I have nothing to do with abortion. Yeah, but it tells me your whole philosophy of government. It tells me you don't believe in absolute rights and wrongs. It tells me you don't believe in protecting the inalienable rights of the people. It tells me you don't believe in limited government, that you want government to replace natural rights. I mean, you get everything from that one question. That's the best way to find out.
Man, I guess if you do that, then